first speaker, though, Jack Hynes. Most of you will know Jack as an insolvency expert. That's how we mostly know him, but his areas of practice, according to the Floors website, are corporate and commercial law, equity, insolvency, restructuring and bankruptcy, and trade practices and competition. But mostly the time I've known Jack, he does, high-end insolvency work of every description. And that would explain why he has been listed in Doyle's Guide for many of the last 3 years. And I think he is now considered preeminent, whatever that means. As I said, Jack has to go at about 1:30. He's going to, let me just find out where I put this. He's going to talk, hang on. He's going to talk on two major topics and a minor one. He's going to talk briefly about the small business restructuring processes and developments in that area. He'll then talk about a recent case, Badenoch integrated logging. And then if there's time, he'll say something about reform. So without further ado, remember people, if you've got questions, put them through on the chat function, which you'll find at the bottom of the screen. And over to you, Jack.
Thank you, Michelle. Can you hear me, Michelle?
Yes, I can.
No, thank you. And I hope you're all doing well. It's great to see a lot of your names, at least, and some faces. And I thank Vynan for his creative explanation for his virtual name. Now, in the last year and a half or so, we've seen, of course, some pretty big developments in insolvency law. And given the time allocated, I'm not going to go through them all, but I'll talk about particularly 2 and maybe 3 if I can get to it in the time topics. As Michelle mentioned, I'll talk a bit about the SBR process that we saw introduced at the beginning of the year and some early issues that I've seen emerge. And then, of course, the already well-discussed developments in preference recoveries. And then if we've got time, I'll look at perhaps some progress in insolvency law reform. So dealing with the SBR process, of course, under 5.3b, the process can be used, as we all probably know by now, by small businesses with outstanding debts of less than $1 million Australian. And there's also a streamlined liquidation process for those entities. Now, the process enables officers to appoint directors to appoint a small business restructuring practitioner, affectionately known as an SBRP, when the company is insolvent or likely to become so at a future time, while the directors remain in office and work to develop this restructuring plan to put to creditors over the 20 business day period. Now, the appointment kicks off a moratorium on the enforcement of creditors' claims against property of the company and the commencement of proceedings against the company or its property absent the consent in writing of the SBRP or leave of the court. And there's also a stay on the enforcement of ipso facto contractual rights that we see. But already there have been some expressed concerns about the exact role of the SBRP and especially the duties owed and the investigations expected of them. And under 453H, the SBRP is stated to be an agent of the company. Under 453E1A, the functions include providing advice to the company's directors on matters relating to restructuring. And under 453J1A, the SBRP is given an express discretion. And if you look at the language, it's may, it's not must. It's a discretion to terminate the SBR at any time if it would not be in the interests of creditors to make a restructuring plan. Yet we go to the definition in section 9, and an SBRP is also an officer of the company. And of course, in times of doubtful solvency, the identity of the company corresponds with the interests of creditors. So while there's no express obligation that I see on the SBRP to terminate an SBR, if it's unlikely to result in the rescue of the company or the business as a going concern, arguably that obligation could be inferred from the current drafting. And that outcome is certainly desirable because if we look at the EM, the aim of the new SBR process is to give more flexibility to viable companies to restructure, not, of course, unviable companies for which the process would simply delay the inevitable consequence, inevitable liquidation. So this is an area that I think we'll see tested in the courts over time. Secondly, the nature and scope of the investigation obligations, they're also unclear in the legislation, and it's reasonable to think that an SBRP does not have the same stringent investigatory obligations that a liquidator owes and a VA, because the SBR process is intended to reduce, of course, the complexity and the cost of the existing one-size-fits-all options. However, if we go to the corporation's regs, 5.3b.18, they expressly provide that the SBRP commits an offence if he or she makes a declaration in relation to the viability of a company under a proposed restructuring plan without making reasonable inquiries or taking reasonable steps to verify the company's business, property affairs, etc. So in the absence of a clear expression in the legislation as to the nature of these reasonable inquiries and reasonable steps and how the standard of reasonableness is impacted by the unique and abbreviated and streamlined process, there'll, I think, continue to be some liability deterrent in completing anything less than a robust investigation. So again, I expect we'll see this in the courts in coming years. Now, we've seen commentary on the investigation requirements, at least some, in two Victorian decisions, which I've seen written up on quite a few times. That's, of course, re Dresco in, I think, February. I think that came first. That's 2021 VSC 94. And then re DST Project Management. That's 2021 VSC 108. That was in March. And they're both judicial registrar decisions coming out of Victoria. Now, they arose in the context of the commencement of a competing winding up application during this SBR process. And under 453Q1, the court, as we know, has to adjourn the hearing of a winding up application if a company is undergoing an SBR and the court is satisfied it's in the interest of the company's creditors for the company to continue the process rather than being immediately wound up. So making that assessment, the court will look at evidence of the prospects of the company and the likely return to creditors compared to winding up. And this is something that will in turn derive from investigations that the SBRP undertakes. So just in these two cases, in Dresco, Judicial Registrar Irving looked at the difficulty of making an assessment without the benefit of a final restructuring plan. However, informing the view that the continuation of the SBR was in the best interest of creditors, the registrar did not require any evidence to support the submission from the SBRP and the company that the company was in fact viable, and accepted, it seems, at face value, the submission that a greater return was expected than in liquidation. So it seems, at least on my reading, that the standard of investigations required might be said to be set at a pretty low threshold. And then there's the other case I mentioned of Judicial Registrar Stephenson in DST. There, the registrar said that there was some force in the view that a lesser standard of satisfaction applies to the assessment under 453Q1 compared to the assessment which the court must make under 440A2 when a company is in VA and there is a competing winding up. Again, this may all mean that the standards expected are set at a lower threshold, but it's a ripe area for litigation, and I expect we'll see a lot more on the issue in the near future. Then, as I mentioned earlier, there's the, again, already well-considered decision in Badenoch, integrated logging, and Bryant, one of the guns pieces that went all the way to the full federal court, where the appeal court overturned what's become an entrenched part of the unfair preference recoveries, the so-called peak indebtedness rule. And the full court also extended the scope of what may be considered to be a continuing business relationship for the purpose of preference recoveries. So beginning with the latter issue, as we know, 588 FA3, where a company and a creditor are in a continuing business relationship, net indebtedness to the creditor is increased and reduced from time to time as a result of a series of payments. The court must take all payments to form part of a single transaction. Only if there has been a net reduction in the company's indebtedness to the creditor across the entire single transaction will have the unfair preference. But in Badenoch, of course, the court rejected this narrow construction that we've seen in a number of single judge decisions, and that there will not be a continuing business relationship where the creditor's predominant concern in receiving a payment is not to enable ongoing supply, but rather recover past indebtedness. According to the full court, provided the ongoing supply of services is not a facade and the creditor genuinely intends to continue with this relationship, even if primarily motivated by the prospect of getting its past bills paid, the ultimate effect of the parties' dealings must be looked at or examined in assessing if there's been a net disadvantage to the company and therefore an unfair preference. Now, this, of course, significantly expands the availability of FA3 in practice, thereby diminishing the prospect of recoveries, overcoming, it might be said, a key restriction that had been read into the provision previously. Additionally, in unfair preference recoveries, if a continuing business relationship is found to exist, then the previous position before Badenoch, which we've seen accepted for some decades, was that the liquidator would use the so-called rule of peak indebtedness to determine when the continuing relationship and therefore the single transaction constituted by multiple transactions began. So what this meant was that the liquidator was not bound to compare the debit in the account at the commencement period with the debit at the commencement of the winding up. Rather, they could, of course, as we know, pick any point during the relation back period, including the point of peak indebtedness of the account as a mark for comparison, being only required to show that from that point there was this net preferential impact. Doing so, of course, allowed liquidators to maximise the prospect of recovery by ignoring prior supplies beneficial to the company before the first payment was made. But this, of course, again, was overturned. The full court said that the rule of peak indebtedness is inconsistent with the plain language of FA3 and is one without coherent justification or rationale. Now, while acknowledging that the absence of the peak indebtedness rule may also result in unfairness insofar as liquidators may be less inclined to pursue preferences as the amount likely to be recovered may not justify the time and expense involved, and this may result in a lower return to creditors, the full court held that the balance weighs in favour of no longer applying the rule in considering whether the payment is an unfair preference. Now, this will, of course, further reduce, in all likelihood, the prospect of successful recoveries in the future. As I understand it, there's an application for special leave to the High Court that's been filed and is likely, I think, that the appeal will proceed, but we'll see. And then separately, of course, the full court has also heard a special question application last month on whether a creditor is entitled to use the set-off provision, the famous 553C2 debacle that hasn't been resolved. So we can expect to hear, of course, another development soon in that respect. I'm just looking at the time. I've got a few moments left, I think, Michelle. Now, in terms of reform, just if I can say a few things briefly, we heard from the Treasurer in May 2021 that the government was going to consult, federal government was going to consult on how trusts are treated under insolvency law. that there be a review of the insolvent trading safe harbour provisions, and a consultation on improving schemes of arrangement processes to better support businesses. On the last point, the schemes consultation began first, with submissions closing on the 10th of September 2021, and that could, of course, result in an entirely new scheme of arrangement process, specifically for insolvent companies, separate to the existing Part 5.1 arrangement. And that, of course, would be a major change in our insolvency system, and would be based on, I think, a similar process that we see in the UK. It was at least adopted in the UK in June last year, which itself was based on, as I understand it, Singaporean and EU nations for some years. Essentially, this process would be intended for large companies, in contrast to the new SBR process, which we see for small businesses, and it could enable directors to have the benefit of a moratorium for at least 20 business days and up to 12 months while they develop the scheme to be voted on by creditors. The federal government has since moved on to the Safe Harbour Review, which will likely be completed by the 23rd of November, and the new Trust Law Review will likely follow by the end of this year. Now, apart from those major reform areas, it's of course worth remembering, with effect from 1 July this year, the threshold at which creditors can issue stat demands on a company went from 2K to 4K, and the new statutory minimum applies to all stat demands served after 1 July 2021. And further, under the repealed and replaced 75/75 of the IPR, the Insolvency Practice Rules, it has been possible since 1 January this year for all meetings to be conducted during an external administration to take place wholly by virtual means, and for all communications to happen electronically. And that, of course, has introduced, I think, significant flexibility and probably cost saving in external administrations. And that reform, as I understand it, is permanent, unlike virtual meetings, electronic communications, and also signatures for insolvent companies, which currently can only take place until 1 April 2022 under the interim legislation. I suppose that gets me to the time. And if there's any questions, throw them on the board and I'll endeavour to respond. Other than that, great to see everyone. And I hope to see you all soon. Thanks, Michelle.
Thanks, Jack. I haven't seen any questions coming up on chat, but that could be because that was actually pretty comprehensive. Can I invite the people watching either to jump up and down on the screen to attract our attention, send something through immediately by chat, or if you feel like it, send something through later and we'll endeavour to answer it while actually not giving you legal advice for free.
Or, of course, send me an email.
Yeah.
Okay.
Terrific. All right. Thanks, Jack. And you'll all excuse Jack if he dashes off. Okay. Our next speaker is Thomas Bagley, who has been a barrister since about 2015. And I think his entire career at the bar, he's been on the 9th floor for his sins. So we are all very used to Tom. He's got expertise across a range of areas. He practices with an emphasis on class actions, commercial disputes, insolvency, professional conduct, and public law. And he's going to talk to us today about practical issues in insolvency duty matters. Hello, Tom.
Hello. So no update from me. Nothing I'm saying will be new or revolutionary. I'll be talking about some issues raised in the context of insolvent trusts and partnerships, with a particular focus on the use of court-appointed receivers as a tool for protecting assets, and some particular issues that arise in the context of making those sorts of applications, which tend to be duty matters. The issue arises in the context of trusts and partnerships in particular, because they're not separate legal entities. Sometimes the legal title in a trustee-beneficiary relationship will be held by a company. Sometimes the trustee will be an individual. often trust deeds provide for the automatic retirement of the trustee on insolvency, and many partnership agreements also have mechanisms in place to try to address situations of insolvency or bankruptcy, either by a member partner or the partnership groups as a whole. When an insolvency practitioner is appointed over the trustee, usually that will come with it possessory interest and control over legal title, which is obviously an important first step, but frequently, in fact, most of the time, won't be enough. And it will be necessary to obtain further relief or other steps to secure the beneficial title and potentially realise beneficial title. With partnerships, this issue arises in the context of insolvency, but this question of when receivers can be appointed also comes up in a slightly different context for partnerships. And that's when there's been a breakdown in the relationship between partners. I don't plan on talking for more than 10 or at most 15 minutes, so everything I say will be very high level. There are a lot of peculiarities to how these decisions are made. There are differences between trusts and partnerships. I won't be getting into them. I will instead try to give a primer of the sorts of issues you should be thinking about if either you're an insolvency practitioner looking to secure or realise trust or partnership property, or you're a solicitor who either is acting for an insolvency practitioner or acting for a creditor of a company that's experiencing financial distress. In this context, the receivers and the ability of a court to appoint a receiver, as opposed to the ability to contractually appoint a receiver, are an incredibly useful practical tool available to insolvency practitioners and also to creditors. And part of the reason for that is that the court has an incredibly broad power to appoint a receiver at any stage of a proceeding where it is just or convenient to do so. And relevantly for most of us, in the federal court, that's section 57 of the Federal Court Act. In the New South Wales Supreme Court, that's in section 67 of the Supreme Court Act. As far as I'm aware, there are similar, if not identical, provisions in most state Supreme Court Acts. There have been a lot of formulations of what the test is for whether it is just and convenient to appoint a receiver, but probably the most useful test, particularly when we're thinking about this from the perspective of preservation rather than realisation of assets, is will the order protect or preserve property for the benefit of someone who has an interest in that property? In the context of a situation where there has been an insolvent trustee, that relevant interest is usually created by the trustee's right of indemnity. That's a right that the trustee has effectively to take from trust property amounts to satisfy any outstanding obligations that the trustee has reasonably incurred in the performance of its functions. And where an insolvency practitioner has been appointed, their fees are included within those reasonably incurred expenses. So often one of the easiest ways for an insolvency practitioner to say, this trustee has an ongoing right to take control of trust assets is, I have a right for my fees to be paid and the trustee has a right of indemnity. But outside that quite clear context, there will be a number of cases where either creditors of the trustee or beneficiaries of the trust may also be able to establish a right to the property and may also be able to make a claim to the court that allows security to be taken to preserve those trust assets. again, in the context where there's an insolvency practitioner appointment or there's an administration of the corporate trustee, the courts have repeatedly said that this ability to appoint a receiver is something that will readily be done, even if it's just to make the process of the administration more convenient or to simplify the process. That's a very low bar. And so although you'll see in a lot of cases about the appointment of receivers, expressions about this is a step of last resort, it's something that should be taken seriously before the order is made. The flip side of that is, at least in this insolvency context, when you look at how is the test actually applied, it's a very low test and an easy one to satisfy. And in the related but slightly different context of partnerships, the analysis is slightly different. There, the question is there a prima facie case that the partnership will be wound up? Or alternatively, is there a reasonable basis to believe that there needs to be an independent investigation into the affairs of the partnership? And so that's a quite an important distinction and addition in the partnership context, that it can be more than just preservation and assets, but also an investigation into whether the partnership is being properly conducted. Once appointed, particularly if there's been an appointment just for the purpose of preserving assets, there'll then be other questions about what more should be done. In an insolvency context, there's an incredibly broad ability to return to court to seek directions about issues, to seek further power, to seek orders for sale of trust assets. Those orders can be made even if the power to sell is, for example, inconsistent with the terms of the trust deed. And the orders can also be made even if there are questions about whether the trust deed even exists or what the proper terms are of the trust deed. That is, the court's not focusing on taking a strict black letter approach here, but really looking towards trying to arrive at a practical, common sense resolution to the issues. So recently, I had a case with a number of the people in this call actually involving the administrator of a group of trustee companies. There were missing trust deeds. There were trust deeds that hadn't been complied with that had vested a long time ago. And there were real issues for the court about whether what the administrator was doing was consistent with what those trust deeds actually showed or what they might have showed if they could be found. But it was possible to work through those issues with the court and obtain orders for preservation and ultimately orders for sale of trust property by doing practical things to satisfy the court of those concerns, leading evidence about what the likely terms of the trusts were for the missing trust deeds, obtaining the consent of the likely beneficiaries, and most importantly, satisfying the court that the orders were in the interests of creditors. I said at the outset that most of these issues will usually come up in the context of a duty matter. Often there will be a real sense of urgency. There will always be at least a sense of urgency from the client, even if it's not a real sense of urgency. Sorry, even if it's not a true urgency. And what that means is things have to be rushed. Mistakes will be made, not because people have done the wrong thing, because there isn't enough time to consider every one of the issues and research every one of the issues that arise in what are often really complicated matters. And so what I thought would be helpful is if I give an indication of some of the things that I think about in the context of these applications, because if you step back and think through these sorts of issues, usually it will help flag those those areas of potential complication. The first important issue is what is really needed? What is the nature of the appointment needed? Am I only ever going to need to protect property, or is it likely I'm going to need to sell the property at some stage? Because the more urgent the matter is, the more important it is you ask for the least you possibly need at that point in time. Because the less you're asking for, the less you're interfering with the property rights of other people, the less you will need to do to satisfy the court. The more you'll be able to get away with a mistake of, for example, not serving all of the necessary people because you're not permanently harming their rights. And so on this question of what is the nature of the appointment, really, from my perspective, the question is, what is the bare minimum I need in order to protect my client's interest? And then the next question is, what will the court be concerned about if I am asking for this? And part of that is, what's the evidence that I will need to satisfy the court? So to use the example I gave before, are there going to be issues like the non-existence of trust deeds that will need to be worked through with the court? What's the sort of evidence that I can put to the court in the 24 hours that I have to show I've recognized this issue and I'm working on it? So in that case, initial steps were taken by the insolvency practitioner to try and locate the missing trust deeds and to explain who the likely beneficiaries were of those trusts and the likely terms of those trusts. And that was enough, given the limited nature of the relief sought and the urgency of the appointment. And what it meant is, when it then became necessary to go back to the court a week or so later to obtain orders that were more substantive, we could say, well, now we've done more. And this is the more that we've done to satisfy the court that these orders are still appropriate. And these more draconian orders that will affect people's rights are still appropriate orders to make. And that final issue, the final issue, other than what will the court be concerned about, is who else will be concerned about these orders? And that's a really tricky area in these cases, because ordinarily, if you are seeking orders that will affect a third party, that third party has a right to be heard. If you're seeking orders 24 hours after you receive instructions, often that third party will not have a right to be heard, or won't practically have an opportunity to be heard because they'll only find out an hour or two before the hearing. It's also tricky in these cases because in the context of, for example, a discretionary trust or a trust without a clearly defined list of beneficiaries, it might not be possible to know who will be affected by the orders. What will be important, though, is doing your best to identify who the necessary parties are and doing your best to serve as many of them as possible. Or in the alternative to that, and particularly if you're just seeking preservation relief, trying to get something less than service, trying to get an email from them, trying to get an information and belief affidavit saying you've spoken to them and they're aware of the hearing. There are two final little practical things that I'll just discuss to finish off this topic. One is this question of whether a receiver is required to give security as an aspect of their appointment. Historically, and it's reflected in the UCPR, there is an obligation to provide some form of security or bond by the receiver for their appointment. And what the rules effectively provide for is that bond to be provided to the court so that if the receiver mistreats or inappropriately disposes of property, there's some security for those people who've been affected by it. That's a pretty substantial burden to place on a receiver who will often be an insolvency practitioner who won't necessarily be interested in providing that security unless someone is supporting the grant of security. But fortunately, courts will usually dispense with that requirement. And I haven't been able to find an explanation in the authorities of why the order will usually be dispensed with, but invariably it is. And it's an important thing to seek, because if you haven't sought it, then the rules will provide for the security to be lodged before the receiver can take any steps. And then the final practical step is it necessary to give an undertaking as to damages? Because what the cases say is the appointment of a receiver is a lot like an interlocutory injunction. And one of the usual features of an interlocutory injunction is the giving of the undertaking as to damages. And the analogy between that and a receiver appointment, where a receiver might come in and take control of a business, and that could have potentially devastating financial consequences for the business if it's not able to be run in the way that it used to be, means that risk of having to give the undertaking is potentially a huge reason against appointing a receiver. But in a lot of cases, courts have worked through whether an undertaking is actually needed, and in many cases dispense with the requirement. So it's just something to flag as an important thing to consider when advising the client. Will this be a necessary component of a receiver being appointed? I think that's me done, Michelle. So,
thanks, Tom. If there are any questions, send them through. We might have time at the end. Let's see how we go. Our next speaker is Michael Swanson. Michael is relatively new on the floor. He's joined what we're finding is an increasingly Adelaide mafia that sort of includes me, but definitely includes Jack and Ben Kosh and other floor members. So Michael started his career as a barrister in Sydney, I think, so at least he's done one thing right, and he's done another thing right by joining the 9th floor. He's going to talk to us about recovery from trust in insolvency proceedings, and that fits into his general commercial practice, which of course includes insolvency, but also commercial equity, class actions, constitutional employment, and in a small departure, sports law. Over to you, Michael.
Thank you, Michelle. Can everybody hear me okay?
Yep.
Yes, excellent. I'll have some slides to bring up in a moment, but I've just noticed a lot of the Adelaide diaspora is also in the audience, so a special welcome to all of them. What I'm going to talk about today has a long title, but I brought a PowerPoint slide with me, if this will work. It somewhat touches on an issue that was raised by Tom when talking about trust and insolvency and how they interact, in particular the rights of indemnity that attach to a trustee and then pass to an insolvency practitioner. A lot of the basic legal concepts around this were helpfully determined in Carter, Holt, Harvey, Wood Products Australia and the Commonwealth, which is more commonly known as Amarant. The single fun fact that I have for today's presentation is that that judgment was so good that it was cited by Justice Derringer the day after it was delivered in a judgment he then delivered in the Federal Court of Australia. So people were keen up on it quickly. The first issue we have is identifying the fundamental rights of indemnity. So what are they and what comprises them? The right of indemnity, as the court set out in Amarant, effectively controls two rights, or is made up of two rights. The first is the right of exoneration. Exoneration is where a debt is incurred on behalf of the trust by the trustee, and the trustee has the right to use the trust property directly to satisfy that debt with the creditor. The second one is the right of recoupment. That is, the trustee incurs a debt in relation to the trust, and the payment of that debt is made out of the trustee's property, from which the trustee then has the right to recoup that amount or that value from the trust property, consistent with the trustee. Now, the identification of these rights will become somewhat clear as to why it's necessary, but it's important to take the first step when you are dealing with an issue of indemnity of a trustee to determine what rights they have under the trust deed, or if there is in fact no trust deed, what rights they have by the conduct that they've taken with respect to the incurring and the payment of trust debts. So hopefully this sets out clearly enough in my diagram what can happen. You have a trust. You have a trust. It has a trustee. That trustee incurs a debt for it. If the trustee is exercising the right of exoneration, they can directly transfer the property of the trust to the trust creditor. Importantly, that transfer can only happen to a creditor of the trust. So that is to a person whose debt has been incurred expressly and specifically by the trustee in their capacity as the trustee of the trust. What it can't be used to do, though, is pay for a creditor of the trustee itself. So that is where the creditor incurs a debt themselves, whether or not that is incurred on the basis of acting as the trustee, or it's incurred in their own private capacity outside of that. Where you should be looking out for issues like this is where you have trustees, corporate trustees that are not just the trustee of a trust, but they also carry on their own commercial activity outside of that. So they would have their own trust creditors. The key here for dealing with insolvency is to try and keep the accounts as separate as possible and make sure we have a clear distinction between trust debts, payments of trust debts, and trustee debts and payments of trustee and payment of those trustee debts and where they're coming from. Importantly, in Amarant, the High Court determined a long-standing inconsistency between the Victorian Court of Appeal and the South Australian Supreme Court. I am more than happy to reflect that the South Australian Supreme Court was found to be correct and the Victorian Supreme Court incorrect. So when dealing with authority that touches on trust, we need to be careful when courts have relied on the case of Hill Proprietary Limited, but should treat with reasonable satisfaction courts that have instead relied on the principles set out by the South Australian Court in the matter of Suco Gold Proprietary Limited. The right of recoupment is the second one and is probably the danger issue that practitioners need to look out for. So that's where the trustee incurs a debt on behalf of the trust, but the way that that is paid either as granted under the trust deed or as a matter of practice of the trustee is paid out of the trustee's property before, and then the trustee can recoup that amount from the trust debt. You see here that this is effectively a two-stage transaction. Often what I've found in practice is that these things, while they appear to be the same in what actually happens, that is, a trustee makes a transfer from an account to a creditor, legally we're dealing with two very separate acts by a trustee here. And it's important that as practitioners providing advice or trying to deal with or head off disputes, we're aware that we would need to identify when trust property is being used to pay debts, whether or not we're dealing with a right of exoneration or a right of recoupment. The danger here was identified by the all 7 justices in the 3 judgments in the case of Amarant. The 2 pluralities are set out at the bottom of the slide there. But that's that where an amount recouped from a trust property passes into the trustee's property, that amount may then be used to discharge the debts of the trustee generally. And where this is an issue is if you have a trust creditor who is owed a debt, but the trustee is only permitted to recoup their losses for it, that trust creditor then falls in line with the other, may well fall in line with the other creditors of the trustee, rather than being able to recoup its losses immediately and directly from the trust, effectively gaining an advantage over other creditors of the trustee. It's a matter that I have seen not come to pass in many matters recently in insolvency since Amarant was handed down, but it's certainly a matter that's threatened to be a problem in a number of matters that I've dealt with since then. My suggestion to everybody is that one does their best to pay attention to what's going on and avoid being the test case that runs after this to deal with some of the problems. And one of the real difficulties that was identified by the court, and I think they are absolutely begging to never have to deal with, is dealing with a trustee who is the trustee of multiple trusts and goes into liquidation. There is then a substantial problem, not only of fact, but of law, as to what happens with property when it becomes intermingled with the trustee's property, and determining the rights that might exist between, so in this case, Trust 1 and Trust 2. The advice here, if you are assisting somebody in setting up such a trustee, or such a corporate vehicle trustee, is to ensure that there are separate funds, so that there is a clear distinction between the trust property of Trust 1, and therefore the rights that are exercised against Trust 1 and the creditors of Trust 1, and secondly against Trust 2. That practical distinction before by the trustee, along with a clear trust deed, is what's really going to avoid future litigation. It's an area that is ripe for appeals because it is a very flexible area of equity in dealing with the trusts. And there are certain members of the bench in a number of courts which I think would be more than excited to get their hands on writing the definitive judgment, which settles a lot of that area of law. So when determining what right the insolvency practitioner is exercising, or the trustee is exercising, the first step should always be to check your trust deed. If the trust deed sets it out specifically saying that a trustee has a right to exoneration that attaches to the property, then we're in very safe territory. And ideally, if we're setting up trusts, that should be the position we take if you want to protect creditors of the trust. The second is to determine whether or not the discretion of the trustee gives rise to a right of exoneration. Now, plainly, this is a much more difficult outcome to both prove and to mediate. The safe position, if you are in this position, is to effectively negotiate with or consult with the beneficiaries and try and form a resolution which, while consistent with the obligations of the trustee and the insolvency practitioner, is not going to cause a dispute between the beneficiaries or the creditors. Briefly here, one of the important takeaways from Amarant is that the court has advised practitioners that where these issues rise in the future, they should approach them from the perspective that it's the purpose of the Corporations Act which will guide the discretion and the direction of the court and the resolution of conflicts and disputes. That is to ensure that certain groups are given priority payments in winding up, be they secured, be they priority because they are the liquidator or employees or another group identified in the legislation. Acting consistently with that, if you are faced with this, is again the safest step to make. And the suggestion here, I will note this was put forward by Gordon, but by Justice Gordon, but agreed to by everybody else. That is the safest way to do it, to try and avail yourself of the court that will eventually hear your dispute. There was one large divide which fell from Amarant, which is important to keep an eye on when dealing with this, and that is what becomes part of the trustee's property. So the plurality led by the Chief Justice was of the view that the legal rights of the trustee to either exoneration or recoupment are assets capable of being circulating assets of the trustee. So they are capable of falling under the control of a liquidator or a receiver or a manager appointed to the company that's being wound up. In contrast to that, Justice Bell, who led her plurality and with whom Justice Gordon agreed, suggested a somewhat more complex position in my view, that it's the inventory, the physical products itself, from which the trustee might draw upon their respective right, which are the subject of a circulating security interest that could only be exercised consistent with the right of recoupment or exoneration under the trust deed. One should treat Justice Bell's judgment as currently the law of the land, but I think it's not yet necessarily finally settled on where that's going to lie, and it will be another strange case that will eventually determine it for us. Finally, just to finish off on this, there are some practical difficulties and practical implications of the judgment which fall. When you identify the right of exoneration or the right of recoupment that is relevant for you, under the Justice Bell's majority, there's not a power to charge trust property. Leaves it open to somewhat a more murky future as to what will happen. My views on this and how it'll go in the future is that there's very much likely to be development of the law in this area, either legislatively or by the court. One of the benefits of the Ameren case is that it was a very simple structure by comparison to trust structures out there. One can readily see that there is likely to be a line of appeal authority which will need to be determined if there are multiple trusts or you have complex trust and trustee structures. Ameren further didn't deal with priority disputes or preference payments. All of these are issues which are yet to be determined, and the only guidance we really have on this at the moment is to follow the purpose of the Corporations Act as suggested by Justice Gordon. Some shameless contact details there, but Michelle, that's the conclusion of my presentation.
Thank you, Michael. That was extremely detailed and thoughtful, and I think we can all see the work that you've put into that. Everybody, unless there are some questions, and I haven't seen any coming through, that will be the end of our session. Before you all go, can I first of all thank each of our three speakers, Jack Hynes, Thomas Bagley and Michael Swanson. Can I also thank our clerk, Ella Baxendale, for the work that she's put together, putting this session together. Can I let you know that we've got another session coming up on the 20th of October. Phil Lonergan will talk to us about paperless practice, including a section, I think, on electronic briefing. This floor is putting together a guide for solicitors who brief us on how to brief us which we hope will give you some assistance in briefing us electronically. Many of you already do that. Many of you are used to the foibles of the individual barristers, although I guess you're used to that with paper briefs as well. Just hold on, I've had a question come through.